with regards to the need for structure. Yes, please go ahead.
Sorry, what is the what is the question I should go ahead on? Sorry, if you can refresh my memory.
That's all right.
About the question that was being asked.
That's fine.
When was being answered.
We were reflecting upon section 201, and I had indicated that what is referred to as the marginal note, perhaps more appropriately the header note, provides for the presiding commissioner. Now, subsection 1 speaks of only the presiding commissioner and provides for the qualification of a person that holds that position, whether presiding or a sole commissioner. And then subsection 2 speaks of when there are more than 2 members, one of the commissioners needs to be a subject matter specialist in the subject matter of the inquiry. And we were reflecting upon 201 because I had wanted you to enlighten myself and the committee on the distinguishing between an establishment and a mechanism. Of course, you had clearly given us what you understood to be an establishment, that it more often is provided for by statute for permanence. It is captured in the budget process. In its operations, it can develop committees and etc. We were going on to make the distinction and speak on a mechanism. Is that fine?
Yes. Now, we were talking about whether the fact that there's a chairperson, if I understood your question, made any difference. And my answer is, doesn't make any difference. Now, if you look at the chapter on commissions of inquiry, which is chapter 18, in tandem with the Act, which breaks it down a little further, you will see that in sections 1, section 2, subsection 3, it provides, that's of the Commissions of Inquiry Act, it says the commission shall specify the subject of inquiry and may.
My apologies. Are we reading the Constitution or the Act?
The Commissions of Inquiry Act. I'm trying to read them in tandem.
Sure.
Because the Constitution is a bit succinct, and understandably because it expects that there will be an act, and there was an act which predates the commission in fact, and which would have been taken into account when the Constitution was being drafted.
Very well.
So if you look at the Commissions of Inquiry Act, sections 2, subsection 2, that's where the role of the chairman, the issue of the chairman is explained. It says, the commission, meaning the commission issued, that document that the president issued is referred to as the commission. The commission shall specify the subject of inquiry and may, in the discretion of the president, if there is more than one commissioner, direct which commissioner shall be chairperson, and direct where and when the inquiry shall be made, and the report thereof rendered, and prescribe how the commission shall be executed, and may direct whether the inquiry shall or shall not be held in public. So all the words that are being used, how the commission shall be executed, means it's a mandate. It's a mandate giving to 1 or 3 people to go and carry out a particular investigation. It's not trying to set up an office. An establishment connotes an office, which is then established, and it's given a structure, and of course, it will also have its own functions, and it may be permanent. But of course, we know there are establishments that can be set up for a short period, for a fixed period. But normally, establishments are permanent. So if you look further at subsection 3, the proviso, which says, provided that the presiding commissioner is entitled to, no, sorry, that's not the one I was looking for. The casting vote, there's a section.
But I would,
section 8.
if we could read that, before we
one?
go to subsection 3. Except
Okay.
as may be ordered by the presiding commissioner to exclude any particular person or persons for the preservation of order, for the due conduct of inquiry, or for any other reason.
Yes.
Okay.
What about it? Sorry.
I just wish for us to make a mental note of it. We can proceed on to 8.
Okay. If you look at the only other role, the commission, obviously, if you have more than one person, you will need to have someone taking care of or in charge of operational issues. You can't have 3 people. They are likely to waste time if you have all 3 people having to arrange the operations of any function, any committee, whatever you establish.
I
Yeah.
agree.
So there must be a presiding commissioner. Is there if there is more than one?
Of course.
So that's logical. So, but one other, I think we can call it an authority that's vested on the presiding commissioner is the casting vote. If the commissioners are in any case equally divided, this presumes that there are 4, maybe they are an even number instead of.
Yes, there could be 2.
There could be 2, and therefore, one of them, the presiding commissioner, is given a casting vote.
Of course.
Obviously, the mechanism that was issued in terms of our own, the one we are talking about, the JANNEH Commission, there are 3 commissioners. So the issue of the casting vote never arose. So the commissioners are equal. But always, we have this maxim, equal inter pares. It's just like a panel of judges. They're all equal. They have to decide, sit down, and agree on a consensus as to the way forward. I assume when it comes to this committee, they're all equal. I don't presume that that's in the nature of committees and presiding officers of committees. But it has no effect or impact in terms of determining or whether the Commission of Inquiry is an establishment or not. The Commission of Inquiry cannot be an establishment because the language that is used in setting it up, it's issued. It's just a commission that is issued. And then the persons who are appointed as members of the commission are called the commissioners. By virtue of the fact that it's a commission, it's a commission, a commission is a mandate. And the other word for commission is a mandate. A mandate given to 3 people to go and investigate a particular matter. And once they are done, they are functus. As soon as they submit their report, they are functus. They cease to exist. So, and that is if you look at the TOR of the commission, it's there that as soon as they submit their report, they become functus, and that brings them to an end. So that's why they are a mechanism, they are not an establishment. Establishments have to be wound up. When they finish what they are doing, they have to be wound up. And so it's an entirely different kind of tool that that's being used. And I think I'd just like to
Is that it? You done?
yes.
Okay. I'll contend with you on that, Ms. Bensouda. I will agree with you that perhaps it is a mechanism and it's not an establishment. We can agree largely on that. I don't see too much of a difference. But with respect to the issue of structure and organogram, nothing that we have looked at in the law suggests that a mechanism cannot have a structure or an organogram. In fact, I would argue the opposite, that everything we have read points to a structure, that that even though there were 3 commissioners, there was one commissioner who was appointed to be the chairperson. And as such, the privileges of a chairperson would accrue to him as the presiding commissioner. And we would see that in section 2(3) of the Commissioners of Inquiry Act, but we would also see it in section 201 of the Constitution. And since we're talking about the structure of the commission, I would like us to be clear on that before we move on to other issues. That indeed there were 3 commissioners, and I would again agree with you that in the exercise of their discretion and deriving at decisions, of course, they're all equal. But to state that all 3 commissioners are equal in a blanket manner, I would certainly contend with. I do not agree with that narrative, and I don't think the committee would agree, because even amongst the committee members, since drawing from your example, there's a chairperson, and that chairperson has powers. Powers of presiding, powers to interject, to determine admissibility, all those admissibility of questions, of course, Ms. Bensouda. All those lead to the commissioners or the committee members not being entirely equal. Again, I will repeat that they could be equal in decision making, such that no one committee member or commissioner can influence the decisions of the other. That I can agree. But to state that all 3 are equal, I contend with. And I would submit that nothing you've said, nothing in the law that you've quoted supports your argument, but rather goes against the grain of your argument, in fact. Can you comment? If you don't wish to comment.
I'm kind of at a loss, because perhaps it's because I'm not quite sure about the rules of procedure before this committee. Obviously, this committee is not a court. So it's certainly the view that council holds may be important when the committee comes to decide. But in terms of my evidence, it's not adversarial. It's not me against you or me against a subject. So I don't have to agree or disagree with you on anything.
You don't even have to comment.
So I don't even see the need to have anything in contention between us. My opinion was sought.
That's fine.
And that is my opinion. And if I may just make a slight comment on something you said, which I don't think is accurate, perhaps in this committee, but in the commissions of inquiry, which are kind of modeled on, for want of suppose a better mechanism on how courts operate, the chairperson does not decide on his own. The chairperson must consult the members, even on admissibility. If there is an argument before the Commission of Inquiry about anything that needs to be admitted, he would consult. He would turn to both commissioners on either side and consult with them, and they would have to agree with every single decision of whatever nature before the Commission of Inquiry. So it's not a situation where the chairman can override and say, this is what I think, and that is what would apply. So I'd just like to correct that. But apart from that, if you do have an opinion, that is fine. But as I said, my evidence, my opinion that was sought is that commissions of inquiry are not establishments, they are not offices, they are mechanisms.
So I would, that's precisely what I'm saying. The point has not been made. At least I don't believe the point has been made. I would leave the rest to the chairperson and the committee. But also I would contend with you again that the all the commissioners need to be at par and need to be in agreement before a decision is made. Then what is the essence of Section 8 of the Commission of Inquiry Act, the casting vote, the overriding vote? When they are at a deadlock, the chairperson can override the decision.
Precisely, that's the casting vote is precisely that. When you have an even number of people and they cannot decide, then you have a deadlock because the number is even. So if you have two people and they don't agree, there's a deadlock and there's need for a casting vote. When you have 4, 6,
and that privilege
8,
is given to the
but
chairperson.
only even when you
Yes.
have even numbers. Obviously, if there's a deadlock, that would be the end of the commission. They will not be able to proceed. So that's why, again, these mechanism which exists not only in commissions, it exists in any decision-making body of people where, you know, there cannot be, there's an even number of people, and therefore there cannot be consensus because of the fact that the numbers are even. One person is giving a casting vote.
Yes.
So that doesn't mean that that person is necessarily more powerful than the others. It's just, again, I hate to keep on repeating mechanism, but it's a legal, mechanism built into corporate, the law by which corporate entities operate. And you'll find it in the Companies Act, and you'll find it in different statutes. You cannot set up a body of people and not make sure that they will not come to a deadlock on any matter, and that will defeat the purpose or the reason why the body of people are being set up.
Of course.
And that's why you have this casting vote. But it has nothing to do with structure, and it has nothing to do with...
perhaps let me ask one question. In corporate culture, who is that casting vote given to?
It's always given to one person among the
And who
group
is
of
that
people.
one person?
It's given to a chairperson.
It's always the chairperson. That is structure, Ms. Bensouda.
I
Anyway,
think we're talking about two different things.
perhaps.
We have drifted away from the establishment.
Yes, we have.
Let's leave it. I think we have drifted away from that. As I said,
We're still within
in
our.
terms of establishment, the language is very also important. Language is important. Establishments are.
Can you dilute on that?
Yes. Establishments are established. And when something is established, it becomes a body of people that is given some legal recognition as an entity. Commissions are not entities. They don't have any legal existence. So they're just mechanisms. They're just mechanisms. And whatever they're doing, when it's over, they're functus. That's the end of it. So.
Okay, just to also clarify a point, I did not mention once that the chairperson influences the commissioner's decisions. In fact, on the contrary, I did state that I would agree with you that when it comes to decision making, the commissioners would be independent. But to say that they're equal in every respect would be an injustice to the chairperson.
Oh.
But we can move on.
Learned counsel.
Yes, learned senior.
You know, there is a way the law operates.
Of course. I believe I've been oriented
So
to some degree.
So when you have a body of people, they cannot all speak at the same time. So you need them to speak through someone, one of them. And that is why you have a need for what we call a chairperson or a presiding officer. Because they consult each other, and one is selected among themselves to speak on their behalf, to convey what they want to do through that person. So the chairperson is just a spokesman in those circumstances. They decide every decision, not only big decisions, every small decision, they have to consult and agree, and one person speaks for them. He doesn't speak on his own behalf. He speaks on behalf of the group. So that's the role of a chairperson, is akin to a spokesperson. Otherwise, it would be chaotic if every member of a group has to speak on the same issue. So they speak, they consult, and then one person speaks on their behalf. That's the role of the chair. But it does not make the chairperson more important than the rest. It does not vest in the chairperson a power that is different or separate from the rest.
I believe
perhaps
that is the point of our contention. Perhaps I would take your advice and say, we can move on. We're at a deadlock. I don't believe we would agree. I would direct you again to section 2(3) of the Commission of Inquiry Act, and I'll put it on record again. It says, except as may be ordered by the presiding commissioner in the public interest, public safety, or public order, the proceedings of the Commission of Inquiry shall be held in public. But then it goes on to say, provided that the presiding commissioner is entitled to exclude any particular person or persons for the preservation of order, for the due conduct of the inquiry, and for any other person. So my position, Honorable Chair, is that the chairperson has a distinct role from the other commissioners. They are the masters of the proceedings. They ensure that the conducive conduct of the proceedings, and in some instances, the Act bestows upon them specific privileges and powers that are not resident in the other two commissioners. So unless you have a comment, Ms. Bensouda, I would contend with you on that, but we can move on since there's no dead end to this conversation. Should we move on?
the proceeding is in your hands.
Yes, I had given you the option.
As I said, these are not adversarial proceedings. You know, it's not me against
Certainly not.
me against you or me against the committee. It's a fact-finding committee, as far as I know.
If it were
As a witness, once I give my opinion, that should be the end of it, and we proceed, because you have the privilege of working with the commissioners, the committee members, and giving them your opinion.
Indeed, but I feel I have a duty to put my opinion on record, especially where the record, I believe, has been tainted by another opinion. I use tainted in a very light word. There is no malice
But
intended.
I suggest you don't use the word tainted, because it does have a
As you
specific
please.
negative connotation.
Okay.
Yeah.
I could not convey it with any other word, but excuse me for that. But I would also say that you are also a witness that guides the committee, and where I feel the committee is not guided, I am at liberty to probe into it, albeit an opinion. Okay. The issue we were contending with, and just before I proceed, Honorable Chair, if you permit me, Ms. Bensouda, it is indeed not an adversarial proceedings, not between you and I. In fact, if I had the option of picking a fight, I would pick a fairer fight. So indeed, it is not me and you. It is all to get facts for the committee. But moving on, we were discussing the difference between an establishment and a mechanism, and your testimony is that the Commission of Inquiry is more of a mechanism, because once it fulfills its mandate, it becomes functus. And still on the organogram, perhaps we can move, we agreed that the Secretariat would have an organogram. We are not agreed on the hierarchy of the commissioners. Perhaps let's move on to your responsibility. It is from evidence we have obtained in this committee from yourself and other witnesses, namely the chairperson of the JANNEH Commission, as he then was, the Honorable Doyen of the Bar, Mr. JANNEH, as well as the Secretary to the Commission, the first Secretary to the Commission, Mr. Alhaji Mamadi Kurang, The second secretary also confirmed that. And just yesterday, another commissioner, in the name of Commissioner Abiose George, confirmed that as lead counsel, your role was to coordinate between the legal team and the investigation team. Their evidence is that you are in fact the head of the legal team and the investigation team. What do you have to say to that?
Firstly, my role was more than that, and my role is set out in my engagement letter.
We will get to your engagement
letter, I set out what I understood my role to be, and
Can
that
you permit me
engagement
to?
letter is was shared with the commissioners.
Indeed, it was. MOJ
Now,
3K, Honorable Chair. If you would permit me, Ms.
now,
Bensouda.
if I may just say,
If I may, Ms. Bensouda, kindly permit me.
You asked a question, or you
I
don't want
did,
an
but I
answer?
want to guide the question. I don't want to leave it in the open. The question is not with respect to your role in entirety. The question is with respect to whether you were the head of the legal team and the investigation team. So if we can confine it to that so that we can move on.
No, I was not head of the legal team. I was the legal team. I, as lead counsel, was the legal team. If you look at my appointment letter and my engagement letter, it said so. It said that and if I may quote from it, paragraph 4 of my engagement letter says, responsibility for advice and services. Services under this letter will be my sole responsibility. No other entity or individual accepts or assumes responsibility or has any liability to the ministry or any third party for the services provided under or pursuant to these terms of engagement. I was the lead counsel. Perhaps the term lead is a bit misleading. I was counsel to the commission, and there were other counsel, but they were all assisting me. So there was no question of their being head of a legal team. The legal team worked under me, under my direction completely.
Certainly, there is no question because you were the lead counsel. So you were leading all the rest of the council. You were the head of the legal team. There is no question. I agree with you.
I was in the head of the legal team. That's what I'm trying to say. I was counsel, and I was responsible for all legal work. I took responsibility for everything that the legal team did. They did it under my direction. Proceed. As regards the investigation, I was not head of the investigator. I'm not an investigator. According to my engagement letter, these investigators were independent police investigators from the Office of the Inspector General of Police or from the FIU, Financial Intelligence Unit. If you look at my engagement letter, again, paragraph 2 is quite clear that with paragraph 2 of my scope of work. The scope of the work which I have agreed to undertake is as follows. And 2, as regards investigation process and correlation of the evidence. So all my functions are set out, what I am required to do. And one of them is to coordinate the investigations to assure the quality of the evidence that is produced, to guide the investigators on the access and production of any matters of evidence outside the jurisdiction, assemble and present to the commissioners the evidence necessary for the conduct of the inquiry on the matters set out in the terms of reference of the commission. In this regard, all evidence is to be submitted to council, whether directly by members of the public or through the secretariat of the commission, or by any investigator supporting the commission. So I was working entirely in accordance with my terms of reference. Perhaps those who gave evidence here did not avert their minds to the functions or my duties under my terms of reference. I was not heading the investigations. I was coordinating it. And Mr. Chairman, if I may explain, perhaps something that is, I think it's important in terms of how the investigation was organized. Under the Commission of Inquiry Act, the commission, when it finished its work, would submit its report and its recommendations. Now, this was changed by the Constitution. Under the Commission of Inquiry Act, the Commission reaches its conclusions, makes recommendations, sends it to the President, and the President then decides whether to accept or not to accept and publish its report. Under the Constitution, 1997 Constitution, commissions of inquiry were kind of elevated to a different level. Now, under the Constitution, when the Commission reaches a conclusion, which I call its findings, then it has to categorize its findings as to what was adverse and affects someone else in a very substantial way and what wasn't. And those adverse findings are subject to appeal to the Gambia Court of Appeal. So in other words, it was not a simple question of witnesses appearing, giving evidence, the Commission reaching a conclusion and sending recommendations to the President. All its conclusions must be conclusions that are supportable at law, meaning when they are challenged, because they are adverse, the matter goes to the Court of Appeal. Those conclusions, called findings, have to be defendable. So it was very crucial to have the services of counsel. Ordinarily, you don't have to have a lawyer in a commission of inquiry, but it became essential because of the 1997 Constitution that evidence that's put before the commissioners and on which they make a finding or a conclusion must be evidence that would stand up in law, that meet a certain standard. And we call it in law on a balance of probabilities. It's evidence that proves the allegation that is that has been made against that adverse party. And so that's why it was important that as counsel, when investigators submit their report, I would look at the evidence and then I would give them advice as to whether that evidence, the standard of that evidence was good enough for the conclusions of their investigations. Because every investigation report would have conclusions and investigators would indicate what their findings are. So before it's presented to the commissioners, part of my role was to look at the evidence and to look at the weak areas, if any, and to say to the investigators, I don't think this is sufficient. I think you should look at this. I think you mentioned this particular witness, but you haven't really made out a case based on what you're saying. So go back and investigate it. So perhaps I needed to explain that. So perhaps to a layperson, it would look like, oh, okay, Mrs. Bensouda is head of the investigators then, and she's the one in charge of the investigation. I wasn't. Investigators, every investigator is independent. They would investigate, they would write a report. That report will be submitted. I'll look at it. If I think it was comprehensive enough, I'll compile the report and the evidence supporting the report. I'll present it to the commissioners. If I thought there were gaps, I'll send it back. But if it was but it was a dynamic process. You know, I can submit part of what they provide whilst they're looking at some other things. So I just want to explain so that there is no misunderstanding. But the investigators were not a body. They were just loose, independent persons taken from the police. Each of them had an area they were investigating. That is how it worked.
Okay, thank you for your guidance, Ms. Bensouda. Please direct us to the part of the Commission of Inquiry Act that you are referring to that differs with the Constitution.
In terms of, I did not, at least in my latest evidence, I did not refer to any part that differs with the Constitution.
Oh, I believe what you are told, the chair, is that previously.
Oh, I see.
Exactly.
Okay, I see what you mean.
Please direct us.
If you look at the Commissions of Inquiry Act, you will see under section 7, which sets out duties of commissioners defined. Section 7 provides that the commissioners, after taking the oath as prescribed, A, will make a full, faithful, and impartial inquiry into the matter in respect of which the commission is established, and conduct the inquiry in accordance with the directions, if any, in the commission, And this is the commission issued by the president. That's what is being referred to. There's the terms of reference. And B, in due course, furnish to the president in writing the result of the inquiry, including a full statement of the proceedings of the commission and of the reasons leading to the conclusions arrived at or reported. Now, if you look at that provision is in the Constitution. But in addition, the Constitution goes on, and in section 204, it has an additional provision that is not in the Commission of Inquiry Act. And it says, there are two additional provisions actually, but I'll start with the one that relates to what I have just read. Section 204 says adverse findings. 1, where a commission of inquiry makes an adverse finding against any person, it shall, at the time of submitting its report to the president, inform such person of the finding and the reasons therefor. 2, a person against whom any such adverse finding has been made may appeal against such finding to the Court of Appeal as of right, as if the finding were a judgment of the High Court, and on the hearing of the appeal, the report shall be treated as if it were a judgment. 3, an appeal under this section shall be made within 3 months of the appellant being informed of the adverse finding, as provided by subsection 1, or such later time as the Court of Appeal may allow. So, in other words, the commissions of inquiry did not have, before the Constitution came into force, they did not have this power. But by the Constitution, section 204, they were given the additional power of actually making a finding, actually saying, we find as a fact that this person has committed, for instance, I'm giving you an example, has committed what can amount to an offense under the criminal code, and they refer to that section in the criminal code. And if they do make such a finding, by this section, they have to serve before, when they are submitting their report to the president, they have to give notice of that finding to the person affected. And that person then has a right of appeal to the Gambia Court of Appeal, because that finding has the same importance as a judgment of the court, of the High Court. So that person can then appeal to the Gambia Court of Appeal against that finding. So that now places a huge burden on the commission, because it means that since the finding of the commission has been elevated by the Constitution to the same level as a judgment of the Court of Appeal, judgment of the High Court, it means that the evidence that the commission relies on in order to come to that finding, to make that conclusion, must be evidence that will stand the usual tests of such evidence in the High Court. Because when a judge of the High Court says, I find as a fact that you did A, B, and C, I find as a fact that you committed theft, it's because there's evidence on a balance of probability that's been placed before that judge. The conclusion has to be based in law. It has to be supportable in law. And that is why it was very crucial. My role as counsel was very crucial in making sure that not every evidence is just taken to the commission and said, okay, this is the evidence and that's it. I have to make sure that at least there's a balance of probability that that evidence, one, it's been properly obtained, and if it goes to the Court of Appeal, it will not be thrown out, and so on. So that was my role. Second, the second difference, and which is fundamental, also, is in section 202, subsection 2 of the Constitution, subsection 2, D. Because if you look at the Commission of Inquiry, the Commission of Inquiry had the power to summon witnesses. Section 10 of the Commissions of Inquiry Act says that commissioners acting under this act have the powers of the High Court to summon witnesses and to call for the production of books, plans, documents, and to examine on oath witnesses and parties concerned, and to make interim orders. Okay, it's the same. Okay, sorry. The making of interim orders is the same. I thought there was a difference, but it's the same. The Commission of Inquiry had. So this is the main difference, is the adverse findings. But the interim orders, both acts provided for interim orders. I think I'm looking at the act. Yes. All right, Council.
Thank you for that, Ms. Bensouda. Now, what we were looking at was whether you were the head of the legal and investigation teams or not. And evidence to the contrary has been registered on our records as a committee. And we wish to just put that to you. That's where we were. You've directed us to paragraph 4 of your MOJ 3K, which is your engagement letter to the government. And I believe you also read paragraph 2, didn't you? If not, let's look at paragraph 2. Shall we? Shall we? Paragraph 2.
Sorry.
Let's look at paragraph 2 of your engagement letter, MOJ 3K. And paragraph 2 says, the investigation process and correlation of the evidence. Perhaps let's get context of that before. Perhaps I can allow you to go through paragraph 2 for us and explain each of the paragraphs under paragraph 2, the subparagraphs rather.
Paragraph 2 is self-explanatory. Do you want me to read it?
Please.
Right. The investigation, paragraph 2 is paragraph 2 of the scope of work on the engagement letter, and I'm reading from the bundle I provided. I'm assuming that the bundle, I think it was tendered in evidence.
Yes,
Yeah.
but just for the purpose of the chairperson and the committee members, it is MOJ 3K.
Very well. Scope of work. The scope of work, my scope of work as lead counsel was divided into 3 main areas. And the 3 areas are: 1, the management and administration of inquiry process and procedures; 2, the investigation process and correlation of evidence; and 3, the proper and effective conduct of commission hearings, whether in public or private as appropriate. And paragraph 2, which is the investigation process and correlation of evidence, has 7 subparagraphs, A to H. And A says, identify the evidentiary issues, the order in which they are to be pursued, and the approach to be taken in pursuing them, as well as the witnesses to be called. B, coordinate the investigations to assure the quality of the evidence that is produced. C, to guide the investigators on the access and production of any matters of evidence outside the jurisdiction. D, assemble and present to the commissioners the evidence necessary for the conduct of the inquiry on the matters set out in the terms of reference of the commission. In this regard, all evidence will be submitted to council, whether directly by members of the public or through the secretariat of the commission or by any investigators supporting the commission. E, to correlate and present all evidence and other material in a coherent and efficient way. F, to determine the selection of witnesses to give oral evidence, the order in which they will be called, and their allocation to different issues within the terms of reference, and to submit to the secretary witnesses to be formally summoned. G, to review all evidence and exclude and minimize the risk of unreliable evidence motivated by malice or bad faith being released into the public domain. H, to act as a filter between the investigators and the commissioners by, among other things, ensuring that results of investigations are properly supported before presentation to the commissioners.
After reading paragraph 2, Ms. Bensouda, can it be said that you did not direct the investigations team?
I did not direct the investigations.
Okay, if we can look at the paragraphs a bit closer, or rather,
And
perhaps,
if I may add,
please.
and it doesn't matter to me what anybody says about whether I directed the investigations or not, because it's entirely irrelevant. This commission is over, it's functus, it has done its job, it has submitted its report. I appeared before it, I have done my job, I have submitted my report. So opinions, persons can hold opinions. Now you have asked me, did I head the investigations? I said no. Now you're asking, can it be said that I did not direct the investigations? I'm saying I did not direct the investigations. And as far as I'm concerned, that is of no moment. Thank you.
Thank you, Ms. Bensouda. Unfortunately, for me, I have a job too, which is not functus, it's active, and it's to probe in these specific issues. So unfortunately, I have to ask these questions, and unfortunately for you, you would have to answer these questions. I wish to look at some of these. Sorry? Oh, okay.
I'd just like to,
Sure.
for the record again, to say that the tenure of all these questions since this morning, or since I started appearing in, before this committee, I did raise the concern, and I'd like to raise it because it's a matter of record. And I'm saying that all these questions are way outside the mandate of this committee. The committee's mandate is not open-ended. This committee is not been set up by the National Assembly to review the work of the JANNEH Commission. That is not in the motion that was passed on the floor. I don't see it there. And nothing in that motion supports what is happening, the tenor of the questions that are being asked. And the committee is subject to judicial review, to my mind. And at the end of the day, we expect that it will produce a report that is consistent with its mandate. So, yes, I've been invited to answer questions, but I do have privileges as a witness. I should not be asked to answer questions that are not within your jurisdiction, which is your mandate is all about, and which is your remit. So I'm here. I will give my best to cooperate with the commissioners. But I think that all these questions, and I don't want to make any statement that questions your work, learned counsel and learned friend. I'm not questioning your role, but I'm drawing your attention to the importance of any committee staying within its jurisdiction. Because staying outside that jurisdiction can tantamount to abuse of authority and abuse of power. And you know this.
Indeed, I know this, and I do appreciate this, Ms. Bensouda, and I'll agree with you that the committee going out of the whims of its mandate would be an abuse. I would disagree with you that we are going out of our mandate. And I believe this issue has already been raised and an order been given. So if we could proceed, since you've done us the kind courtesy of answering our questions, I would continue to say paragraph 2. We look at it, if we look at it, and perhaps if I may note, just from counsel to the witness, that you see, the responsibility of the National Assembly extends to advising the president on policy, on the president's policy considerations. And while the mandate is clear, Anyway, let me stop at that. The Assembly should advise the President on policy issues, and this work, your testimony, will go a long way in enabling the Assembly to do that. Thank you. Paragraph 2, the investigation process and correlation of evidence. Now, the first limb talks about identification of the evidentiary issues. And then when you go to B, it says that you are responsible for coordinating the investigations to ensure the quality of evidence that is produced. C says that you are responsible to guide the investigators on the access and production of any matters of evidence outside jurisdiction. D says that you are also responsible to assemble and present to the commissioners the evidence necessary for the conduct of the hearing. Now, a wholesome reading of paragraph 2 indicates that, indeed, the investigation team were under you. Any comment?
No, I don't have any comments. You're entitled to whatever opinion that you form.
Certainly.
I don't have any comments.
Certainly. I would ask the Secretariat to also furnish the witness with SC6. SC6, but in the witness can also, since the witness has a bundle, can look at MOJ 3G and MOJ 3O and O. SC6, Secretary to Cabinet 6. O.
SC. I know the volume itself is SC, but how do you? Okay. Oh, you're going by the folio. Okay.
Honorable Chair, can I proceed? Thank you. Let's begin with SC1, which is SC6 rather, which is a letter dated the 20th of July 2017, just days after commission was set up, and precisely 3 days after you resumed work, because you've informed the committee that you resumed work on the 17th of July 2017. Now, this is a letter that...
I assume.
Sorry?
I
assumed rather, my apologies, yes. You assumed work on the 17th of July 2017. 3 days later, a letter was issued from the commission to the office of the president under your hand. I will allow you to give us the contents of the document.
Mr. Chairman, this letter is in the bundle of documents I provided also. It's reference COM/CL/volume 1/09 dated 20th July 2017. And this is one of perhaps, I don't know whether it's hundreds of letters I wrote to various institutions.
Could you help us, please? I'm not sure the mic is going. Or could you, yeah.
As I was saying, this is one of a series of documents I wrote to various institutions and organizations when I assumed my duties on the 17th of July 2017, and this letter was dated 20th July 2017. In my bundle, I have given what I call examples to show what I was doing during that period. So the letter is addressed to the Secretary General, Office of the President, State House, Banjul. And for the record, it was Mr. Fadera who was Secretary General and was very helpful in our investigations. And it says, "Dear Sir, the Commission investigations. As you are aware, I have been appointed counsel to the above commission, which has started work from the JAMMEH Beach Resort, formerly JAMMEH Beach Hotel, Kololi. My duties include the coordination of the investigations and compilation of all evidence relating to the TOR for presenting to the Commission. In this regard, it would be greatly appreciated if the following information could be submitted to the Commission as a matter of urgency. 1. The names and contacts of all persons who have served as Secretary General, Cabinet Secretary, and Chief of Protocol from 22nd July 1994 to 21st January 2017, which was our mandate. 22nd July 1994 to 21st January 2017, the period during which they served, their current whereabouts and contacts if known. 2. All remuneration, including salary, allowances, gratuity, and pensions earned by the following persons during the aforesaid period: ex-President JAMMEH, Lady Zainab JAMMEH. 3. The bank and bank accounts into which the remuneration were paid. 4. The payment vouchers and any other supporting documents for the payments. And it goes on to say, it would also be helpful if a suitable officer from your office could be identified to work with the investigation team in order to facilitate interface between your office and the inquiry and the retrieval of necessary information. Please note that this request is urgent, and we would appreciate receiving the information on item 2 and 3 in particular before the 28th July 2017. I count on your cooperation. Yours faithfully, and I signed Amie ND Bensouda. Copy, Secretary to Commission.
Let's look at MOJ 3O and 3G as well, because they're under the same belt.
MOJ 3.
3G and 3O.
MOJ 3G. Can please, can I be assisted?
If the Secretariat could assist the
If
witness.
it's in this bundle, I'm not sure.
you need not read the entirety of the letters, but because they are quite similar, and you have hinted to the fact that within that period you wrote to several institutions. Perhaps you could just explain these two. And they're, like
Mr.
you
Chairman,
said, they are just examples from the many letters that you were issued under your hand.
yes. Mr.
proceed.
Chairman, I wasn't actually hinting. In my letter to this committee, dated 17th July 2025, in the bundles that were admitted, the first bundle, I'll draw your attention to page 2, in which I stated the sixth paragraph,
What page is that, Ms. Bensouda?
bundle 1 to 81. It says documents 1 to 81, 2017. If you look at the cover letter that I wrote, dated 17 July 2025, the cover letter, Chairperson Special, it's addressed to Chairperson Special Select Committee. It's the first document in that bundle, the very first document.
Ms. Bensouda, is it dated the 17th of July?
Yes, 17 July.
Perhaps if you can allow me to guide. It's the cover letter, honorable members.
It's the cover letter.
It's not in the bundle, quite. It is on its own.
So it's in the bundle as well. The bundles, documents 1 to 8, first document. It's not there?
That letter is not
If you
attached.
can allow me to just guide. Our copies came with the cover letter. So there's a cover letter and 3 bundles. So
Very
you're referring to the cover letter. It is AB2, Honorable Chair.
AB2. Okay, thank you. So it's a letter dated 17 July 2025, addressed to the chairperson of this Special Select Committee, and copied to the clerk of the National Assembly, headed re-response to summons to produce. And on page 2 of that letter, paragraphs 1, 2, 3, 4, 5, the 6th paragraph, I said, I effectively started my engagement on the 17th July 2017 and moved to JAMMEH Hotel. Consistent with my TOR, the first 2 weeks, 17th to 24th, was spent on addressing logistical issues, planning, organizing the investigations, writing to all public institutions listed in the Commission TOR, meeting with the commissioners, developing templates, including for summons, notices, etc. Sample letters written during the period are attached, and I attached about 20 sample letters. And these are some of the letters that I wrote during that period. That is the first one that I read, and this second one, MOJ 3G, written to the Director of Civil Litigation and International Law of the Attorney General's Chambers. That's MOJ 3G. And it says the Commission of Inquiry Investigations. And the first 2 paragraphs are usually the same. As you are aware, I'm the lead counsel for the aforesaid newly established Commission of Inquiry. My duties include the coordination of investigation, etc., relating to the TOR. And one of the issues being investigated is the tax commission. It would assist us greatly and enhance the investigations if you can provide us with reports of the tax commission, all correspondence thereto with the Office of the President, Gambia Revenue Authority, GRA, and any other government authority relating to the case. Furthermore, a summary of all those paid, I think there's a typo there, all those paid and to which account. This matter should be treated with urgency. So I wrote hundreds of these letters.
Yes. And perhaps I would excuse you from reading MOJ 3O. I will do that myself. It is addressed to the Solicitor General and Legal Secretary. It was dated the 9th of August 2017, and the subject is with reference to commission investigations, like all the other letters. With reference to commission investigations, as you are aware, I am the lead counsel for the aforesaid newly established commission of inquiry. My duties include the coordination of investigations and compilation of all evidence relating to the TOR for presenting to the commission. It is my pleasure to introduce Mr. A name is provided as one of our new investigators. He is assigned to collect information and documents in your office relating to the assets of the former president, Yahya AJJ JAMMEH, full stop. We count on your usual cooperation. Yours faithfully, signed, undersigned, Amie ND Bensouda, lead counsel, commission secretary, copied. Now, 3 days after you assumed your position, letters were issued to different institutions, informing them of the Commission of Inquiry's investigations. MOJ 3, or you even had cause to introduce one of the investigators to the Attorney General's office. From the evidence we have gotten, once again, from yourself in form of documentary evidence and the viva voce evidence of 4 witnesses rather, my apologies, place you as the head of investigations. Your engagement letter not only also places you as the coordinator of the investigation team, but it also goes to say that in paragraph 2 of the scope, paragraph 2D, it also goes to say, and I'm reading from the middle of the paragraph, in this regard, all evidence is to be submitted to council, whether directly by the members of the public or through the secretariat of the commission, or by any investigators supporting the commission. I would also direct you to the tail end of paragraph 3, paragraph 2. The end of scope, after the paragraphs on the scope, you have a paragraph headed team. Can you see it? It's on page, yes, the engagement letter, MOJ 3K, honorable members. It's on page 3. Do you see it, Ms. Bensouda? Do you see the paragraph I'm referring to?
Yes.
If you could kindly just read that paragraph alone. And I would say that you need not read the names. You are at liberty not to read the names. If you wish to read it, as you please.
In addition to the investigators,
if you could
and the 2 assisting
get closer
state
to the
counsel.
mic, Ms. Bensouda.
In addition to the investigators and the 2 assisting state counsel from the Attorney General's chambers, a senior associate of my firm will assist me in the commission at no extra cost. Is that the one?
Yes, that's the one. That is a paragraph that describes team, but I would not want to put to decipher my interpretation of it without at least giving you a chance to decipher that paragraph.
I don't understand your question.
It's not, my question is for you to elaborate on that paragraph.
It speaks for itself. There's nothing to elaborate.
Fantastic. Then, if it speaks for itself, what it says to me is that your team, because it's headed team, it says, in addition to the investigators, which I would presume would be part of your team, and the 2 assisting state counsels, who I also assume would be part of your team, a senior associate of your firm will assist you at no extra cost. Am I right?
No,
Do you want to take the courtesy now and explain?
it's self-explanatory. This is my engagement letter before I even took, what is it, Peter?
That's fine, Ms.
This is my engagement letter, and I was informing in the engagement letter, I was indicating who I was going to bring, in addition to the resources that the government was going to provide. The government is providing investigators. It's in the TOR of the commission that was issued by His Excellency the President, that investigators will be provided. And in my discussions with the Attorney General, it was agreed that he would provide state counsel who would support me, because we all recognize that this was a very extensive investigation. And obviously, in terms of what I would agree to, fees to be paid, and so on, I needed support. And he agreed he would provide state counsel for 2 reasons: to expedite the investigations and as a learning process, so state counsel can learn from the process. And team, from an engagement letter, means who is going to come from my office and will constitute the team. And it was going to be myself and 1 senior associate. That's what is intended. You can give it a different interpretation. But I must say again, anyway, let's go on. Let's leave it.
I think it's healthy that our laws are tested, and if, again, you wanted to raise the issue of the jurisdiction or mandate, I would encourage you, Ms. Bensouda, once the report is finalized, to test the law.
Can we proceed, Council?
Yes, we can.
Thank you.
Team, it says, in addition to the investigators and the 2 assisting state counsel from the Attorney General's office. In addition to, like you said, it speaks for itself. And I wish to seek clarity on this, because it's not clear, Ms. Bensouda, that your team was just yourself and an associate from your firm. If that was the sentence, if that sentence entails that a senior associate of your firm will assist you in the commission at no extra cost, it would be clear that the team is just 2 people from your firm. But it says, in addition to the investigators and the 2 assisting state counsel, feeding into the narrative that has been given to this committee by 4 other witnesses, which are consistent. And it's also consistent with this paragraph of your letter of engagement, which suggests that you were the head of the legal and investigation teams. No reaction, I presume.
Was I called upon to react? I've already answered the question, Council.
That's fine. We can move on. Honorable Chair, you take note of the witnesses' answers, and we can proceed.
Council.
Yes, Honorable. I'm consulting.
No, I was going to say, I think it is going to be a convenient time for us to.
I don't think it is. I think we can go for another 30 minutes.
30 minutes.
Yes. It's your decision. I think we can do another 30 minutes.
All right, Council. I mean, you know the standard time for our normal break is from 2 o'clock going upward. But then since lunch is not around, we can proceed at least 30 minutes, then we can go out for break. 2:30, huh?
Thank you, Honorable Chair. Just to wrap up this issue, Ms. Bensouda, from your testimony again, it's 3 units: commissioners, the lead counsel, sorry, commissioners, lead counsel, and investigation team, which is in contrast to all the other evidence the committee has received, which seems to picture it as commissioners, lead counsel, and investigation team, and then secretariat. In either case, there are 3 limbs, but the way it's described differs. We move on to the operations, just maybe 2 questions on operations. It is indicated in paragraph 2D of your engagement letter, and also in RS4, if the witness can be furnished with RS4 to look at, which is a memo that was issued to the second secretary, just defining the scope of work between the secretariat and the team of counsels or lead counsels team. And perhaps I'll give it a moment for you to be furnished with RS4. Are we there? Can I proceed, Ms. Bensouda?
Yes, certainly.
Sure. Let's look at the second page. Well, before I go to the second page, this is a memo dated the 11th day of July, 2018. Of course, by that time, the first secretary had been relieved, and the second secretary assumed position as the substantive secretary, even though under the title assistant secretary. And this is RS4 is a document that sought to clarify the role of the work between counsel's office and the secretariat. And I would allow you to give us a rundown of this document, since it was also done under your hand.
This is a memo. I'm trying to remember it. I did not sign it. I'm not saying I did not write it, but memos usually I would endorse the memo against my name. I would endorse it against my name. But I'm trying to remember it. However, it seems to be to Assistant Secretary, 11 July. Well, I think yes, we had an Assistant Secretary at that time, but there was no secretary immediately after the 10th July. So it must be, if I wrote this memo to Assistant Secretary, then the person who was in charge of the Secretariat was the Assistant Secretary. And the memo is subject work between Council's office and Secretariat. So it outlines well, it's divided into different sections, and the first one is on summons and notices and how this work. The second one is memo, emails, and outgoing communication, and how communication between my office, lead counsel's office, and the Secretariat, how it was coordinated. Then documents, schedule, oath exhibits, and transcripts. How also this was coordinated, and it's a briefing. It's a briefing memo, so to speak, or guiding. I'm sure guiding the Assistant Secretary as to what was expected.
The last paragraph
So,
is
then there is stationary, water, fuel, and phone credits.
okay.
How this was also managed, and council team and contacts, council and or team and contacts. So you have the list of lawyers that were at the commission at the time. Some were from my office. Three were from my office. Two were from the AG's office. I recognize these. And there's a legal assistant from the judiciary, and two legal assistants, I think. One from the judiciary, one from the AG's office. Then there are 5 investigators, all listed with their phone numbers.
I wish to draw your attention to the caption in the heading. It says council, team, and contacts. Again, I can only conclude from what I deduce from the documents. The document is a memo to the Assistant Secretary. At the time, the first secretary, Mr. Alhaji Mamadi Kurang, was relieved. The second secretary was appointed on the 10th of July 2018. And that is Ms. Ramatullah Sar. And on the 11th of July, assuming that it's her first day at work, the day she assumed the position, a memo was sent to her from you or your team, giving her clarity on the work between council's office and the secretariat. You see, even the subject refers to council's office as an office. So we go from team in your TOR to office here. And on the last paragraph, the heading is council, team, and contacts. And the composition, there's a 12-man team. Or rather, there are 12 names under that caption: council, team, and contacts. And against each name is their position and their telephone numbers. You can see that there are two groups of personnel in this 12-man list. There's the legal team and there's the investigation team. So from everything the committee has received, it is a natural conclusion that you were the head of the legal team and the investigation team. I wish for you to react.
I don't have any reaction, And I think I'll need to seek clarification from the chair. From the tenor of the questions today, questions have been put to me regarding my role in the commission, and reference has been made to evidence by the 3 or 4 other witnesses who have come and said I headed the investigation. So I just need to be guided. What is the issue here? Because I'm a witness of this. I was summoned to come and give evidence. But I don't really understand what the issue is that is being investigated. So if it is said that I headed the investigation team, and is there an issue that I need to answer? Because I keep on going back to why I am here, and I'd like to draw your attention to Section 119 of the Constitution, 1997 Constitution. Section 119. Section 109 is about the committees of the National Assembly, and this is one of, just before I go back to Section 119, Section 109, I note, of course, is what gives this committee its mandate, and that this committee was actually appointed or established pursuant to Section 109, subsection 2B from the motion that I was shown. And subsection 3 sets out the powers of the committee, and it says, for the purpose of effectively performing its functions, each of the committee shall have all of the powers, rights, and privileges as are vested in the High Court at trial in respect of enforcing the attendance of witnesses and examining them on oath or affirmation, B, compelling the production of documents, and C, the issue of a commission or request to examine witnesses abroad. So, first one, to your powers, I've been summoned and I have appeared, and I was given a summons which indicated what I was being summoned and the question that I'm required to answer. Now, Section 119 gives me certain privileges as a witness before this committee. Subsection 1 says every person summoned to give evidence or to produce any paper, book, record, or other document before the National Assembly or any committee of the National Assembly shall be entitled in respect of his or her evidence or the production of such document, as the case may be, to the same privileges as if he or she were appearing before a court. Now, my concern is I have a feeling, I may be wrong, and Mr. Chairman, you can correct me if I'm wrong, that I have a feeling of somewhat being blindsided. In other words, I've been invited here to give evidence with regard to assets. I come here and I've been appearing for 3 days running. And it seems as if my appointment is being questioned. My role in the committee is being questioned. I'm being told that witnesses have come here that are giving evidence in relation to what my role was and wasn't. So I'd like to be guided whether, if I am under investigation, because it sounds very much as if I'm here trying to defend something I'm not aware of. So if there is an issue, I expect that this committee will put it fairly and transparently. Mrs. Bensouda, this is the issue here, and we would like your evidence on it. But to be asked questions which to me, as I have said, I don't see the relationship between the questions I'm being asked and your mandate, that's for one. Two, it's being put to me that consistently, that 4 witnesses have come and said, I headed the investigation. Then I ask myself, even if they said so, so where are we going with this? I think I need to know. Simply, I need to know what it is that, what is it that is being investigated in relation to what these witnesses said, so that I can advise myself. In the situation where I am in a court, no witness can be invited to a court and be asked to give evidence on issues that have not been squarely put on record. So I'm being questioned on matters, I don't know what it is that I'm being questioned about, frankly. Because nothing I've been invited to come and give evidence on has been asked. All this is about my appointment. The National Assembly cannot set itself up as an authority to question what the president did in relation to appointing a commission, or how the Attorney General appointed a counsel to the commission. So I don't really, but besides the point, that's an opinion. Besides the point, you have your motion which was passed on the floor of the National Assembly, and it is specific. It is specific. You are required to investigate the assets, the disposal of assets that were identified by the commission. What do I know about it? What is the role I played, if any? That's what I expect. But all these questions, it seems there are accusations or allegations that have been made by witnesses that I'm required to answer, but I don't know what these allegations are. So if there are allegations I'm called upon to answer, I need to know what they are. I don't want to come here and be disrespectful by saying I will not answer a question. But your powers are not infinite. I have rights as a witness. If there is an issue, it should be put frankly on the table, and it should be addressed properly and transparently. So I want to know what it is that is being investigated. What is the allegation against me that I'm being called upon to answer to? I know one person in public media and public space, and I said it before, has made allegations, and the questions that I'm being asked are very similar to the allegations that they have been made. If this committee is investigating allegations made by Mr. Mamadi Kurang, I should be told, so I can come ready to answer to those allegations. I will still protest that it is not in your terms of reference, insofar as the allegations don't relate to assets. But to be honest, it's not right, it is not fair, it's an abuse of power for me to be brought and be questioned on allegations I have no notice of. And I'd like it to be on record.
Honorable Chair, if you can give me, I would start from the bottom up, and to say that unequivocally, first of all, I would start, if you would permit me, Honorable Chair, to say that the National Assembly currently has 6 lawyers in its team. Each of those 6 lawyers holds the witness in the highest esteem. Even if we know that the National Assembly is a political institution, but no council would sit here and allow Ms. Bensouda's name to be dragged. Let me state that unequivocally first. Having said that, this is not a campaign against you, Ms. Bensouda, or rather, let me address the chair. This is not a campaign against the witness. Yes, Mr. Alhaji Mamadi Kurang was before the committee, and he made several allegations that it's only fair that we put it to the witness for her to clarify. But before Mr. Alhaji Mamadi Kurang came, the chairperson came and he made the same assertions. Subsequently after that, the second secretary came, made the same assertions. Subsequently after that, just yesterday, not even 24 hours ago, Commissioner Abiyosi George made the same remarks. Now, they are not allegations, so to speak, because our mandate is to look at the sale. But if you look at the motion, our mandate cannot be realized by looking at the sale. We need to know what role individuals played in the sale. And that goes back to appointment. That goes back to what your TOR was. We have dealt with this issue many times, and If it were a different witness, I would insist that we have dealt with this issue and move on. But because we hold the witness that is before us with the highest esteem, I want to put this on the record, like she has put hers on the record, that this is not a witch hunt. The questions administered from this table would never have any undertones. And every issue that I go on, especially from proceedings today, I tell the witness that we want to discuss about such and such. The first issue I told the witness rather, was we wanted to discuss the two orders, MOJ 5A and C. We discussed that. I was transparent to you, Ms. Bensouda. The second issue I had informed the witness was the appointment when they just started, and when they started on the 17th of July, 2017. And the third issue is the issue of the role of investigations and the role she played in investigation and operations. Before each of these issues, before I delved into each of these issues, I made it clear to the witness that this is what I wish to speak about. Again, I would contend with the witness and say that all the questions being administered are within our scope. They go to the greater extent of advising our mandate. And I would still stand on that, Honorable Chair. I would also go to say, and I do this grudgingly, that the JANNEH Commission was also issued with a legal notice number 15 of 2017. And therein, there were a list of properties that the JANNEH Commission were to scrutinize, to distinguish whether they were the former president's assets or state assets. But within the course of their work, inevitably, they had to discover, they discovered several other assets. One can argue that that was not within the scope, but it is consequential because it's a connected matter. And when we couched our motion, all connected matters, such as those issues that I'm putting to the witness, are admissible. Thank you, Honorable Chair.
All right. Thank you so much, Council. Thank you, Ms. Bensouda, for raising that concern. And of course, I also want to put it on record. I think we have discussed about this issue the last time you appeared. And from your own self, you did say you wanted to support this committee to give them information that are going to be part of the facts that we're going to present to the public. And I did tell you, yes, we definitely want you to support us with facts. But you will also realize that this committee, since we started work, and I said this the last time, the questions that we are asking witnesses are strictly within the mandate of the committee. And some of the things that we receive from other witnesses, of course, Council said it, it will be only fair for this committee to put those questions to you, just for your reaction, to confirm either yes or no. And I think that is exactly what the committee is doing. Like Council said, the lawyers that we have in the House that are supporting the committee, these are also young lawyers. Of course, we are proud of them. They've been doing a very good job. I'm not sure they will advise this committee at any point they feel that this committee is going out of their mandate. I'm very much sure they will advise us. And of course, also we have other people within who are actually watching the operations of this committee. Whenever we are going outside the mandate, I'm sure they will definitely tell us. We appreciate that you raised the concern, of course, and that is your right as well. But I think we are definitely within the remit of this committee. And then I will indulge you to cooperate with us and support us to get information that is relevant for our work. At the end of the day, the report will be out, and then we will see what happened till then. But I am very much sure that the council have stated very clearly, and that is I think that's the position of the committee. Of course, we are within the mandate to operate. Thank you.
Thank you, Madam, Mr. Chairman. I certainly will not belabor the point. But one thing I'd like to draw your attention to is with regard to investigations, and I hope that you said something very important, that I'm a witness, and when I'm asked a question, it's yes or no. But when I ask a question from the style, when I answer yes or no, that doesn't seem to be enough. The question is repeated in different forms. Other people came and said something. No, my answer is the same. It won't change. So perhaps we should try to avoid the delay, because really your time is valuable, and I'm no longer a spring chicken. I don't want to be sitting here hours and hours on believing. When I give my answer, that's it. That should be it, and we move on. But let me just on the investigations and how things work. It's a pity, I think. I don't know what SBS JANNEH, whom I hold in very high regard, said, but I hope, and I'm sure whatever it is, there is a misunderstanding somewhere. There is a commission report, 9 volumes, and volume 1 outlines how the commission operated. And in terms of investigations, I'll draw your attention, I don't know whether you have the volumes here. Let me draw your attention to page 11, and I hope that will resolve the matter of investigation so that hopefully we can move on beyond this point.
Ms. Bensouda,
Volume 1.
Volume
1,
yes, if you could just give the committee a few moments to.
Volume 1, page 11.
You can go ahead.
So if you look at from that page, I think the heading was method of work from the previous page. This is volume 1, and the commission was explaining how it worked. So 3 is method of work, and if you go to paragraph D, on page 11, it said, in one of our meetings, it was agreed that in order to avoid chaos, all letters of complaint or information concerning witnesses or potential subjects of investigation were to be addressed or directed to the Secretary to the Commission at our JAMMEH Hotel address. The letters would ordinarily be submitted to lead counsel to the Commission. A team of investigators worked with counsel who would direct the investigation of persons considered useful as witnesses and or potential subjects of investigation. Great care was taken not to point at anyone as a close associate without the chance of giving oral evidence before the Commission in a public session or submitting written statements. This assignment to counsel to the Commission, notwithstanding the commissioners reserved to themselves, this assignment to counsel to the Commission notwithstanding, the commissioners reserve to themselves the power at any time to call or recall any witness to testify or swear an affidavit for the use of the commission. Then E, preliminary investigations. Pursuant to Section 15 of the Commissions of Inquiry Act, 5 police investigators were assigned to the commission to assist with investigations and the obtaining of evidence on various subject areas within our mandate. Their main duties involve gathering of preliminary evidence for review by counsel, interviewing witnesses or people of interest to the Commission, inspecting properties of the ex-president, family members, and close associates, and conducting follow-up investigations directed by the commissioners or counsel. Next, page 12. The investigators reported to counsel and worked under her supervision, both as a team and individually. The investigators reported to counsel and worked under her supervision, both as a team and individually. Their findings could prompt further investigation into specific issues or trigger investigation into other areas. They were, in the main, responsible for providing or prompting the production of a major part of the evidence presented to the commissioners at public hearings. There was a level of separation between the investigative process and commission hearings, which allowed for free and private dialogue between the commissioners and counsel, between counsel and the investigators, and rarely between commissioners and the investigators. This was necessary to avoid any possibility that the commissioners may be exposed to and influenced by very preliminary and untested evidence. The inquiry was organized this way in order to maintain a strict division between functions in order to ensure, that the general processes of the commission were all conducted in a transparent, fair, and non-prejudicial manner that averted any possibility of bias on any issue, subject, or against any person. This is how the commission worked. It is already in the report. So to my mind, witnesses coming here and giving their opinion about a commission that it's done with functus 6 years afterwards, it's neither here nor there. With respect to my learned friend and the commission, it's a mere waste of time. It is in the commission report. Nothing they say can override this report. This report is paramount. Nothing any witness can come here and say, this report is the report to the president after commission is finished. This is the legal report of the commission. And it's all here. How the commission work? What is the relationship? The relationship was functional. It was not hierarchical. That's what I'm explaining. The relationship was functional. You are responsible for this. You are responsible for that. This person is responsible. And we work together in a seamless manner. It's not hierarchical. The chairman cannot control me. I was lead counsel. I cannot control the commissioners. I cannot control investigators. I can tell them, go and investigate this, but I cannot say anything about what they bring. I will look at it and say, look, this is not enough. Go and check. I don't think I can present this. That is, it's functional relationship, very dynamic, but it's not hierarchical. So really, that's my final answer on the point of the investigators. I really don't have anything to add. This is in the report. This is how it worked. I have nothing to add. So please, I hope you will accept my answer so that we can proceed.
Honorable Chair, I would like to state that this is an investigation. The committee is also conducting an investigation. An investigation has to take a position sometimes and prove or disprove that position. And consequently, I will have to ask my questions in different phases. I'm sure the witness, being lead counsel, understands that. But also, what the extract that was just read, with all due respect, Ms. Bensouda, it aligns with what the 4 testimonies before this committee. I'll just read 2 of the extracts, and I'll leave it there since the witness has also left it there. I'll leave it to the chair. But it says, a team of investigators worked with counsel who would direct the investigations of persons considered useful as witnesses and or potential subjects of investigation. That's one. The second, I would say, it's the beginning of a sentence. The investigators reported to counsel and worked under her supervision as both as a team and individually. Those 2 statements, with all due respect to the witness, somewhat substantiate what the 4 witnesses have stated. Now, the witness has all liberty to dispel what they have stated and explain. And some of our explanation, I believe, the committee sees the rationale as to why perhaps she would be assimilated to leading it. But it's important that the witness is given an opportunity to react to what others have stated, especially for our report. To you, Honorable Chair. I would state that perhaps once the chair has deliberated on the matter, once we get the answer to my question, which I can ask again, we take a break. That would be then a convenient place.
Okay, just before that, maybe you allow colleagues to do a reaction.
I just want you to inform the committee the document you are just reading now. Can you make a reference to it so that we know?
The
Well-
document has been referred to us by the witness, and it's volume 1 of the
Report.
report.
Page?
It
No,
is page 11,
All right. Okay.
and it's paragraphs. It's the paragraphs that are
Yeah,
headed
you've seen it.
method of work and
Yeah,
preliminary
That's okay.
investigation.
Honorable Fofana want to react as well.
Chair, this will be a quick one. I think the first thing I want to put on record is we could all remember the other time the witness appeared. She did indicate that she's currently going to court, but she wouldn't mind to answer questions which might be related to that. So, Chair, I just want you to put it on record that the witness have the right, if at all questions are asked, which you believe might be prejudicial to your case, to bring it before the attention of the committee. And if you do, the chairman will make a determination after legal consultations. Okay, so please do. You have that right. Okay? Any question that is being asked and you believe it will be prejudicial to your case, you have the right to bring it to the attention of the committee, and a consideration will be done. And a precedents have been set to that during the inquiry of the joint committee, where a particular entity appeared with their legal representation, with their lawyer, and then they brought forth their case that some of the questions that were administered are prejudicial to the ongoing case before the courts. But Chair, also to buttress that, the Assembly does have the powers to advise the executive with regards to what? Their operations. That goes to the heart of parliamentary culture. And that's exactly what we are doing. And again, just Chair, to remind the witness that the Assembly does not operate on rumors or ill will. Everything we are doing is backed by the Constitution and our standing orders. And honestly, there is no abuse of authority here. In fact, we are giving the witness the opportunity to make clarifications with regards to certain things that were said. And all we want to understand is the operations. You cannot go direct into sales if you don't identify the processes that lead to the sales. And that's exactly what we are doing. Thank you very much, Chair.
Thank you, honorable member. Yes, Council, you may proceed. Maybe the witness will help us. Ms. Bensouda, if I recall very well, the question was specific on one thing. That was the reference of you being the one leading the investigation during the commission. So yes, your response was no. And I think what I've seen Council was trying to do is to, get facts from the report and present it to you that this is exactly what the report says. So maybe that question is important if he can ask again, and then you help us to clarify.
It's-
and we move
there-
on.
not
the
from the
question was
report.
whether I headed the investigation. And that was the question, very specific. Whether I headed, I said I was head of I'm not head of the investigation. The answer is in the report. All these documents that I'm being referred to now, these were all documents that were before the commission, that were formed part of the records of the commission. And this is the report of the commission on those documents. This is the report, the 9 volumes. It's a summary of all the work the commission was doing. And volume 1 sets out the procedure, if you are interested in the procedure, the relationships between the different functions and how the commission operated. And this volume was volume 1. All these volumes were written by the commissioners. And method of work is set out, how we related. And nowhere does it say I'm head. Let me just give you an analogy so that we understand, because I take the point that not everybody here is a lawyer. Let's take the relationship in terms of investigation between the Director of Public Prosecutions and the Inspector General of Police. When the Director of Public Prosecutions is the one responsible for taking the investigation file from the Inspector General of Police, they hand it to the Director of Public Prosecution, and for the Director of Public Prosecution to prosecute, go to court. But when the police bring a file, the State Council look at the file, and the file will say, okay, this is all the witnesses, these are the facts, and so on, and this is our opinion that an offense has been committed. The lawyer looks at it, and knowing fully well what it is that has to be proven when he goes to court, he then lists, no, this is missing, this is not there. What you have said does not amount to murder, for instance, if the case is murder. You have to go and check. You mentioned a witness, but you haven't really said what that witness said. Go back and interview that witness. That does not mean the Director of Public Prosecution heads the investigation. It doesn't. It doesn't. So we have to be very careful about the use of the terminology we are using. There are two distinct bodies. Inspector General of Police, investigation office is within Inspector General. They investigate, hand it over to the Attorney General's chambers, where you have the Director of Public Prosecution, where you have State Council. The file is given to them. They look at it. They can send it back and say the evidence is not sufficient. Does that mean they are head of the investigation? They are not. Investigation is a function that is separate from what I did as counsel advising the commission. My job was to advise, was to review, was to check, was to say, no, go and check that witness. No, do this. You can call it direct. But I have nothing to add to what the commission report says in terms of my relationship between myself and the investigators, myself and the commissioners. It's all explained. So I don't think there is any need I don't want to be the one to say, I'm not trying to direct what you're doing at all. But if you have 9 volumes, the premise of the investigation should be what is in those volumes, and not what people who were in the commission said. Whatever they said, to me, to my mind, not to me, but to my mind, and in my humble opinion, it's not relevant, because they were part of the commission. They had done what all of us, we were part of the work for the commission. We had done what we were supposed to do. The commission is finished. Everything is reflected in their reports. So,
yeah, that's
really,
that's fine. That's okay.
I don't have anything else to add on this thing about my relationship with the investigators. I refer you to what the commissioner said.
That's fine. I think we have gone through this part as well in the first volume. We have read the acknowledgement and all that, but we will leave it there. Honorable Sir, you can react.
Honorable, my question still stands.
No, we are coming back to you.
All right,
coming back to
thank
you.
you.
Thank you very much. Yeah, my concern here is about the team of individuals that you are working with, the team that you are working with.
Yes.
Honorable Chair, if it's a question, I advise that I finish my questioning. Yes, I just have one last question. Please. Ms. Bensouda, I would now abandon my assertion that 4 witnesses came to the committee, but I would definitely ask it a different way, and I would appreciate if you would just indulge me on it for the last time. Volume 1 of the Commission of Inquiry's report states that the investigation team reports to you. And a memo that you issued to the secretary, the assistant secretary, also makes an inference that your team comprises of the legal team and investigation team. Are we to take it that are we to deduce from both these documents that those descriptions are inaccurate?
I have already said that the relationship I had with the investigators is the relationship that is described in the report.
So we take what is in the report as
yes,
sacrosanct.
what is in the report.
As you
Yes, that is the status
Honorable
quo.
Chair. Thank you.
All right. Thank you, Council. I think it's a convenient time for us to take break. No, that's okay. We can take break and for lunch and press, and we can come back at 3:30 again. What's the time now? After 3 is no. Give me a minute. Quarter to
Honorable Chair, I would advise that we come at 4.
4
Just-
4 o'clock.
just-
no. It's 2. It's already. Yeah, 4 o'clock is
Honorable
fine.
Chair, I advise we come at
4
4.
o'clock is
yes.
fine. 4 is fine. It will be just 1 hour 15 minutes. That's fine. That's fine. Meeting adjourned till 4 o'clock, and we will resume. Thank you.